Have you ever stopped to think about how the world's largest democracy actually wrote its own rulebook? Well, that's what we're diving into today. This is the story of the Constitution of India, a document that was literally forged in the fire of independence and designed to guide the hopes of more than a billion people.
So first things first, let's just wrap our heads around the sheer size of this thing. At about 145,000 words, it is by far the longest written national constitution on the planet. And listen, that's not just a fun fact for a trivia night. That length tells you everything you need to know about how incredibly complex and ambitious this whole project really was.
And that massive size really gets to the heart of the challenge, right? I mean, think about it. The people writing this weren't just setting up a government. They were trying to build a nation from the ground up. They had to create one single blueprint to unite a country with countless languages, religions, and cultures, all while trying to heal these deep, deep wounds left by centuries of colonial rule and a violent partition.
So, faced with what really seems like an impossible task, how did they even begin? Let's unpack how this incredible blueprint came to be.
Okay, so this was not an overnight job, not even close. The whole process took almost 3 years of non-stop intense debate. 2 years, 11 months, and 18 days to be exact. It actually started before India was even officially independent, with this group called the Constituent Assembly. A special drafting committee, led by the absolute genius Dr. B.R. Ambedkar, was the one that really steered the ship. And after wading through literally thousands of amendments and arguments, the final document was adopted in November 1949. It officially came to life on January 26, 1950, a day that's now celebrated as India's Republic Day.
And to really get what they were trying to do, you just have to hear these words from Dr. Ambedkar, the Constitution's chief architect. He basically argued that political freedom, the right to vote, is totally meaningless if you don't have social freedom. The Constitution couldn't just be a rulebook for politicians. It had to be a tool for a social revolution, one that baked the ideals of liberty, equality, and fraternity into the very soul of the nation.
But, okay, that's a beautiful, grand vision. How do you actually make it real? How do you turn that into law? Well, the framers' answer was something truly revolutionary for India at the time, a charter of fundamental rights for every single citizen.
Now, here's the most important part about these fundamental rights. They aren't just suggestions or nice ideas on a piece of paper. They are legally enforceable guarantees. They're meant to be a shield that every single citizen has against the power of the state. This ensures that individual freedoms are protected and that the government can be held accountable. And that simple idea, well, it's the bedrock of Indian democracy.
And the scope of these rights is just incredible. The Constitution guarantees everything from the right to equality and freedom of speech to the right to practice your own religion and protect your culture. But look at that last one on the list, the right to constitutional remedies. This is the one that gives all the other rights their teeth. Because think about it, what good are rights if you can't actually enforce them? That's exactly why Dr. Ambedkar called this specific right, Article 32, the very soul and the very heart of the entire Constitution. It gives every citizen the power to go straight to the Supreme Court if they think their fundamental rights have been violated. It's the ultimate check on power.
But, and this is a huge but, writing these incredibly powerful rights into the Constitution immediately created this fascinating tension. It set up a legal tug-of-war that would basically define Indian democracy for the next several decades.
And here it is. This is the core conflict. On one side, you've got Article 368, which gives the elected parliament the power to change the Constitution. But on the other side, you have Article 13, which gives the Supreme Court the power of judicial review, meaning it can kill any law that messes with fundamental rights. So this set up the ultimate question. Is Parliament's power to amend absolute? Could it, in theory, just amend away the fundamental rights themselves?
The first time this battle went to court was in 1951. And in this round, the Supreme Court sided completely with Parliament. In the Shankari Prasad case, the court said, yep, Parliament's power to amend is unlimited. It can even change the fundamental rights. So round one, pretty clearly, went to Parliament.
But then, whoa! Just 16 years later, the pendulum swings all the way back. In a 1967 case called Golaknath, the Supreme Court did a complete 180. It declared that fundamental rights were sacred, they were untouchable, and that Parliament had zero power to amend them, at all. And just like that, the judiciary had the upper hand.
So now we've got a real constitutional standoff. The elected parliament and the country's highest court are on a collision course. How do you solve something like that? Well, the answer came from a landmark ruling that created a legal concept that is uniquely Indian.
The big climax arrived in 1973 in the legendary Kesavananda Bharati case. After the longest hearing in the history of the Indian judiciary, the Supreme Court came up with this brilliant and historic compromise that would totally redefine the balance of power for good.
And that compromise is called the Basic Structure Doctrine. It's an elegant solution. The court basically said, okay, Parliament, yes, you can amend the Constitution. Go for it. But you cannot use that power to damage or destroy its core identity, its basic structure.
So what exactly is this basic structure? Well, the court was pretty smart here. It never gave a final, complete list, which allows the idea to evolve over time. But through various judgments, it has identified certain core principles. You know, the big stuff. Things like the supremacy of the Constitution itself, the rule of law, separation of powers, and the secular and democratic nature of India. You can think of these as the foundational pillars of the whole building. You just can't touch them.
And look, this was not just some abstract legal theory. The doctrine proved it had real-world power after the controversial period of national emergency in the mid-1970s, a time when many democratic principles were suspended. The 44th Amendment, passed in 1978, was a direct result. Guided by the principles of the Basic Structure Doctrine, it acted as a massive course correction, restoring the powers of the courts and putting back the checks and balances that had been wiped away.
And that brings us right up to today, because the Indian Constitution is not some historical relic sitting under glass in a museum. It is a living, breathing document. And those fundamental debates that shaped it nearly 75 years ago, they are still very, very much alive.
I mean, just look at these recent cases from 2024. The Supreme Court is still figuring out that delicate balance of power, this time between the central government and the states. Whether it's siding with a state's right to challenge a central investigation or confirming a state's power to collect its own taxes, these modern rulings prove that foundational ideas like federalism are constantly being tested, debated, and redefined. So we end up right back where we started, with a huge fundamental question. This whole 75-year journey, from a massive 145,000-word document to the elegant Basic Structure Doctrine, has been one long, constant negotiation of power. And it leaves us all with this thought. In this ongoing contest for a nation's soul, who really is the final guardian of that foundational blueprint? Is it the will of the people, spoken through their elected parliament? Or is it the wisdom of the law, interpreted by an independent judiciary? The answer, it seems, continues to be written day by day in the life of the world's largest democracy.